What is sexual harassment? Under both state and federal law, sexual harassment includes unwanted and offensive behavior by someone in the workplace toward another person. Hi, this is Paul Padda of Paul Padda Law. If you're watching this video, you might be searching for a Las Vegas sexual harassment lawyer. Or maybe you just have questions about sexual harassment and want to know more about your legal rights. Either way, you've come to the right place. At my law firm, we've been representing Nevada employees for more than a decade. My firm handles all kinds of employment cases, including claims involving sexual harassment in the workplace. Here's what you need to know. Sexual harassment in the workplace is illegal and just plain wrong. Under both state and federal law, sexual harassment includes unwanted and offensive behavior by someone in the workplace toward another person. The conduct is either sexual in nature or discriminatory because of that other person's gender. Sexual harassment can even occur between two people of the same sex. Examples of sexual harassment include things like unwelcome touching, comments about sex, derogatory jokes about a person's sexual orientation, solicitations for sex, sexually explicit emails or text messages, and any other unfair treatment based upon a person's gender or their rejection of sexual advances. Now, in sexual harassment cases, there are two main legal theories under which all claims are brought. The first is known as the quid pro quo theory. This is where an employment benefit is conditioned upon a sexual favor. An example would be a supervisor telling a subordinate, "I'll give you a raise if you sleep with me." That would be a quid pro quo theory of a sexual harassment claim. The second type of claim is what we call a hostile work environment theory. And this is where a coworker or a supervisor heaps so much emotional or physical abuse on a person, making it impossible for them to do their job. That would be an example of a hostile work environment. Not all conduct, however, necessarily rises to the level of sexual harassment. And this is an area where the courts have often created distinctions that sometimes can be a little confusing. Courts have held that behavior must be significant enough to have a substantial impact on your ability to perform your job. It has to have a negative impact in order to be actionable as sexual harassment. Because the standards of what constitutes sexual harassment can be a little bit unclear, it's really important to consult with a good employment lawyer to get the right advice. How can you sue for sexual harassment? Well, if you believe you're the victim of sexual harassment at your job, you can sue. But you need to go through a number of procedures first. For starters, the law requires that you quote unquote exhaust your administrative remedies. What does that mean? It means that before you can even file a lawsuit in court, you have to present your claims to a government agency with the authority to investigate employment claims, and you have to do it within a certain amount of time. You have to give the agency time to investigate your situation, and then once they investigate and the government agency gives you the green light, only then can you move forward with the lawsuit. At the state level, the state agency that investigates workplace sexual harassment claims in Nevada is the Nevada Equal Rights Commission. At the federal level, it's the United States Equal Employment Opportunity Commission, informally known as the EEOC. You can't file with both, but if you file with one or the other, each will investigate it the same way. So it really doesn't matter. Once you get the green light from whether it's the state agency or the federal EEOC, then only can you pursue a lawsuit. And you have only 90 days to do it from the time they tell you you can move forward. If you miss that deadline, you're going to be prevented from ever pursuing a claim. Does this sound complicated to you? Well, yes, it can be. And for this reason, it's super important to have a really good employment lawyer representing you. What type of damages are available in a sexual harassment case? When you sue for sexual harassment, you can sue for both economic and non-economic damages. The most common type of economic damages include things like loss in pay, what we would refer to as back pay, the cost of medical bills, maybe even the cost of therapy if you've had to go see a psychiatrist because of the harassment. Non-economic damages include things like emotional distress, which is also commonly referred to as pain and suffering. Pain and suffering for everything you've had to endure as a result of the sexual harassment, both in the past and the future effects of that sexual harassment. In some cases, you might even be eligible for punitive damages. A question I get asked a lot is, how much does it cost to hire a sexual harassment lawyer? At Paul Padda Law, we handle sexual harassment cases on a contingency basis. What does that mean? That means you don't pay us anything unless we win something for you. Other law firms may charge differently and many charge by the hour, but we believe the contingency arrangement is the best and most fair way of charging our clients. Under a contingency arrangement, you don't have to worry about legal bills as the case proceeds. Instead, you just let us take the stress and help you get a good resolution to your case. If you're dealing with sexual harassment in the workplace, get in touch with us at Paul Padda Law today. You don't need to suffer in silence. Call us today and let us help you. Remember, we bring justice to the workplace.